But the primary submission is based on that reference that I originally gave you. I also gave it to you, I think, after lunch on Wednesday, which is a comparison of the list that appears in Mr. Jenkins's affidavit compared to the First Nation report and the difference between the two.
The issue with regard to the exclusion of certain First Nation groups was not raised in the founding papers. Is that correct?
Yes, it was.
Lady, if I can, part of my argument is to take you to the complaints about the AFMAS report, and I'll immediately concede it was not well pleaded, but there's a set of complaints that set out in Mr. Jenkins' affidavit, and that also your ladyship wasn't taken to. We would, and I'd like to be given the opportunity to work through that in the course of my argument.
I will most certainly give you an opportunity, but I am concerned because one of the respondents referred to it as an ambush, and it's the court's duty to prevent that from happening. Because
Indeed,
we are now at the reply stage, we're at the end of the road today, and for the applicant now to say that there were irregularities in the public participation process insofar as it relates to First Nation groups. It's a serious statement to make. It's a serious submission
Indeed,
to make at this late stage. And it's not contained in the founding papers. The second applicant was actively involved at some stage. He withdrew at a certain stage. So most certainly that must have been information within the knowledge of the applicants at the time when they filed their papers. So I'm just raising my concern to you that the respondents could possibly be prejudiced if you making additional allegations of irregularities with regard to the public participation process.
Lady, if I can just get the references for you, but
yeah, just tell me which volume so that I can get it out.
I'll immediately concede that it was imperfectly pleaded.
Oh, it wasn't.
But there are references to it, and the important one that your ladyship's attention wasn't drawn to by my learned friend is the one where Mr. Jenkins sets out his complaints in relation to the process. I think your ladyship is correct. It may well be that he doesn't refer expressly to exclusion, but certainly our submission would be that the impact of his methodology and his approach was effectively to result in exclusion. And there it says, while the formal requirements of PADJA were complied with, the consultation was not meaningful. It is clear and they rely on...
you are reading, where are you reading paragraph?
Paragraph 135.5.
0.5. Yes?
It is clear to the Heritage Western Cape that there has been a lack or avoidance of meaningful consultation with First Nations groups. Heritage Western Cape is further disappointed that in the instances where comment has been received, this comment has seemingly been dismissed as a difference of opinion rather than a meaningful interrogation of the concerns raised. So I accept that it's not perfectly pleaded, but when we say absence of meaningful consultation, we would submit it would be legitimate to examine the documents upon which the record is based, and to say from that, and your ladyship to infer that a group of
Is
people
this
were
a
left
quote from somewhere? This is a quote.
Indeed, lady.
Where would that be in the HWC's comments or report?
I think it's in their letter of 13 September 2019.
Yes.
It's in the letter of 13 September 2019, if I remember correctly.
So this is a quote taken from a letter
Indeed,
that
lady.
where HWC made comments with regard to...
Indeed, lady. But I mean, one of the bases upon which the applicants are criticised is they've hung by the coattails of the Heritage Western Cape. But, lady, yes, that is how we pleaded our case, and there was a logic to that because of the fact that they're the ones who dictate the requirements. So the respondents can't have it both ways. They can't say you hang on the coattails of Heritage Western Cape, But when there is something that Heritage Western Cape has said that is relevant in that regard, we can't claim that as part of our pleaded case. So
What
we
is
say
the
that,
date of this letter?
I think it's 13th of September 2019.
2019.
Pardon, ladies. The final comments of the 13th of February
Final comments.
2020. So the final comment was the 13th of February 2020, and that starts at page 270.
But the applicants on their own version, they do not have any other objective evidence that points to failure to consult,
It points
except to rely on HWC's comments. Is that the position?
No, I'll come to Jenkins' affidavit, and where
Yeah.
he sets out all of his complaints in relation to the AFMAS process, and that was with the founding affidavit. So it's certainly part of the case that was presented. But I think there's also a paragraph then of the letter of the 13th of February 2020. So E reads, results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. 96, it is noted that the applicants have conducted an engagement with First Nations grouping, which culminated in the First Nations report submitted to HWC on 4 December 2019. There are a number of issues with this report, namely, A, the scope of engagement resulted in a number of groups electing not to participate fully. The research process was contested by participants in the engagements. The impartiality of the research questions is not clear to the committee. The methodology for the engagement does not appear to follow accepted oral history interviewing protocols. For example, no ethical clearance forms were supplied. Confusion between this report and the Department of Transport and Public Works Commission report brings the
Can you
ethics
pause
around
one
the
moment,
engagement
please? I'm
question.
only interested in the public participation aspect of what you refer to now. The applicants didn't raise this issue in their founding papers. So what does 97(1)A mean? Can you contextualize it for the court, please? You cannot make a vague statement and then you don't substantiate it, because I asked 8 respondents to give an indication of the figures, how many groups are there, how many groups were excluded, etc. The applicant relies on AWC's submissions, and the court did debate that issue already, because HWC withdrew from the process at a very crucial stage when the minister required assistance. Now, what does 97A mean for the applicants? Not the HWC, what does it mean for the applicants?
Well, that I don't think is on record. I don't think I can refer to an affidavit that says what's on record, except to the extent that it's taken up in Mr. Jenkins' supporting to the founding affidavit. And lady, I think we can only fairly judge it once we've had a chance to look at that.
But I need to ask the question directly, because we're at the end of proceedings today and public participation is very important. So if you can direct me anywhere in an affidavit, a document, to clarify what A means to the applicants, where will I find Mr. Jenkins' affidavit? I don't want you to move to any other point. I want us to stay with public participation, because I don't want to muddy the waters and then we refer to other issues, whereas public participation is very important. And all the parties already addressed the court on the issue of public participation. So, which volume will I find Mr. Jenkins' affidavit?
At or around the time that Mr. Arnser presented his Trapp First Nations report to a stakeholder group at Oudtshoorn as part of the HIA public participation process, it came to my notice that he had been engaged by the developer. In our view, this meant that Mr. Arnser had a conflict of interest. The impetus for the additional engagement process was because First Nations groups had been unhappy with the lack of meaningful engagement with them by the developer and the consultants. And now the person facilitating that process was under contract to the developer. This, coupled with my earlier concerns about the absence of proper ethical safeguards, convinced me that Mr. Arendse was not to be trusted. Consequently, the Gurungai Corner refused to engage further with Mr. Arendse. So already one sees a reference there to unhappiness with the lack of meaningful engagement with them by the developer. So with respect, that is certainly a complaint about a form of exclusion or dissatisfaction with the process that was being engaged in. And with respect, my lady, the AFMAS report, when we talk here about a failure to consult, we're talking about a failure to consult in terms of paragraph E of section 38.3. We're not talking about a failure to consult on a PUDGA. We're not talking about a failure to consult in terms of the environmental impact assessment regulations of 2014. And I'll come back to this to make specific submissions. But in relation to, and let me make the submissions now before we go further. That paragraph.
Can you just pause one moment? Paragraph 55. The paragraph referred to additional engagement. It says additional engagement.
My understanding is that he's referring back to the first TRAP report, and the additional is, as I read it, what's coming now directly with the developer, the process that's been initiated by the developer in response to the 13th of September 2019 letter that's been received from Heritage Western Cape.
I also don't see any statement in paragraph 55 that a specific group was excluded. I don't see it there.
Well, it says it doesn't
It's vague.
identify a particular one,
It
but
is
it does
vague,
say
yes.
First Nations groups had been unhappy with the lack of meaningful engagement with them by the developer.
Is the applicant, or I must say, are the applicants, I don't just want to refer to second applicant, are the applicants in a position to tell the court who were excluded from the process today, as we stand here today? Are the applicants in a position to identify those groups?
On the basis of the earlier exercise that I showed you, which is to compare the relevant part of his affidavit where he lists the groups and contrasting that with the First Nations report. So let's do that exercise, lady.
Second applicant participated and subsequently withdrew. So second applicant's position is clear to the court. The court needs clarification.
In relation to the
any
others.
other groups excluded, and the court cannot find it in the on page 731.
Indeed, my lady, and there what I've said is that there are two potential sources. The one we've already drawn to the court's attention, which is a comparison of the list that comes later in his founding, if I can call it founding affidavit, compared with the list in the First Nations report. So the difference has to be those who weren't consulted, because Arendse's report is finite as to who he was consulting with.
How can the court ascertain whether any groups were excluded if the applicants cannot contextualize it, verbalize it, and provide the court with that information?
That's the best submission I can make. In addition to the list that I said that we would provide to your ladyship by way of a table, which comes from the appeal in relation to the provisional protection order. I can't do better than that. It isn't articulated better than that.
Does it mean that the applicants are incapable of providing the court with a list to state unequivocally which of the First Nation groups were excluded from consultation and participation? Are the applicants not in a position to provide that information by mentioning the names of the groups?
If if, as I understand the process that has been permitted in respect to the 8th respondent correctly, and I speak subject to correction, and we were allowed a similar process where we could go outside the record in the proceedings, then I have no doubt that we would be able to provide a list. If I'm understanding the procedure that is being engaged in by the 8th respondent, and it seems to me that the applicant should in those circumstances have a similar opportunity to identify those who were left out through a process that's extraneous to the record.
Well, the applicant, the eighth respondent clarified to this court that there were 6 groupings in the first. Let me just check my notes that I made. That is without any note or any additional information. The 8th respondent. Oh, sorry, where am I now? Oh. The first group there were 8 different groups within the first group. And apparently the second applicant forms part of that first group. So the second applicant is the only group in the first group that did not participate until the end. He did participate, or they participated
in the original TRAP report.
Yes,
indeed,
but not the second leg of the
Indeed, lady. But I didn't understand, and I speak subject to correction. I didn't understand the information coming from the 8th respondent to be referenced to specific places in the record where one could identify that.
No, the 8th respondent, sorry, I'm just looking for my note. 8th respondent, but perhaps the 8th respondent can just remind the court the reference of the page, please.
At volume 6.
Volume 6.
Oh. And it was from the founding.
Learned friend related through the mask. Apologies.
And it was from the founding. And it was from the founding affidavit of Charles Jackson, and
oh yeah, it's 2530. Sorry, I found my note. You mentioned that there were 5 houses.
Correct.
In the first group, there were 6 divisions. 2530. Let me just check.
And I've read from paragraph
2531.
from paragraph 7.4, where I refer the court to, firstly, to the 5 houses generally, and when it came to the Cape Koi house, these are the groups in 7.4.
Yes.
And
Forms part of the first group.
they form part of first group, indeed.
And second applicant formed part of that.
And the second
group.
applicant formed part of the first group,
Yes.
but opted out of the
Yes,
process.
at some stage, yes. So so 8th respondent referred to the papers.
As the court pleases, there were two other sources. The one is the list of participants in the appeal process in relation to the provisional protection order, and unfortunately that isn't in hard copy form yet, but we can arrange that. And I'm told that the grouping that they belong to can be determined with reference to Mr. Jenkins' affidavit.
Sorry, I cannot hear you.
I say that I'm told that the grouping that they belong to can be referenced through reference to Mr. Jenkins' affidavit. And if one looks at both of those documents, I'm told that Ms. T. Walensky is there as Korana. Mr. K. King is there on behalf of the Kochokwe Traditional Authority. Kai Korana Transfrontier under Kubaha Melvin Orense. Captain J.C. Witboy